I declare open this hearing of the Senate Community Affairs Legislation Committee's inquiry into the Aged Care Bill. I begin by acknowledging the traditional custodians of the land on which we meet today and pay my respects to their elders past, present and emerging, and I extend that respect to Aboriginal and Torres Strait Islander people here today. The committee will be conducting today's hearing via video conference and in person. My name is Senator Marielle Smith. I'm the chair of this committee, and I have with me today Senator Hughes, and we're expecting Senators Orman, Payne, Pratt and Ruston. Oh, we've got Senator Orman Payne by video conference, I can see. Welcome, Senator. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. The Senate has resolved that an officer of a Department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. I now welcome representatives from the Department of Health and Aged Care. For the Hansard record, could you each please state your full name and the capacity in which you're appearing today, and we'll start with Mr Lai.
Michael Lai, Deputy Secretary, Ageing and Aged Care Group in the Department of Health and Aged Care.
Thank you.
Amy Laffin, First Assistant Secretary, Quality and Assurance Division. Mel Metz, Assistant Secretary, Legislative Reform Branch.
Great. Welcome to you all. Mr Lai, do you have an opening statement?
No, Senator. No, Chair.
All right, we'll now go straight into questions then. So I would normally pass the call to the opposition first.
No, do you want to go to Payne first?
Yeah. Senator Orman Payne, did you want to kick us off, and then I'll have some questions as well?
Yeah, thanks, Chair. Happy to do that. Is my sound working okay?
Yep, we have got you clear. Thank you.
All right, thank you. Just took a while to kick in at my end, so thought I'd best check. Thanks, everyone. At the last time we saw the department, I asked some questions around the decision-making aspect of the bill. And I think the response that I received was along the lines of it was necessary to have those provisions in there because the current Act doesn't refer to individuals, and therefore those provisions are now in the Act. We've heard a lot of evidence in the hearings that we've since had suggesting that these provisions are quite problematic. There seems to be confusion between supported decision-making versus substituted decision-making. And there also are concerns, I think, from providers around how the state-based guardianship laws, etc., actually interact, and certainly concerns around the fact that those state-based laws require quite lengthy processes to be gone through in order to make determinations about who are those decision makers. So I'm just wondering if you could come back to those supported decision making provisions. First of all, clarify whether they're meant to be about supporting someone to make a decision as opposed to actually substituted decisions, and then to make it clear, if it is about substituted decision-making, then what are the processes actually that are going to be gone through that means that it won't be inconsistent with state guardianship legislation?
Thank you for
and
the
just
question.
To let,
Sorry.
Oh no, I was going to say I didn't have a visual on the department, but I do now. Thank you.
Thank you for the question, Senator. I'll just start by noting that peak bodies that represent older people have advocated very strongly for including supported decision-making arrangements in the bill. The model on which that framework is based comes from an Australian Law Reform Commission report, but there has been more recent endorsement of supported decision-making through the Disability Royal Commission. So we've looked to those arrangements in coming up with the model that's in the bill. Supported decision-making recognises that capacity to make decisions is not black and white, and it exists on a spectrum and can fluctuate, and that's especially true in aged care for people with dementia. And what supported decision-making means is that rather than substituting a new decision-maker when a person's decision-making capacity diminishes, people are supported to make decisions for themselves for as long as possible. There's a single concept of supporter rather than a dual representative and supporter framework in the bill, recognising that capacity isn't static and that a person might need different levels of assistance and support day to day. The model incorporates state and territory frameworks to determine when a person may have decision-making ability on behalf of someone else, and that ensures consistency as far as possible across those arrangements. So there is a substitute decision-making in the bill, but that's at the very end of that spectrum of supported decision-making for those people who absolutely cannot make decisions, even with support.
So can I just...
Yeah,
so just when it gets to that point of substituted decision-making, is it your view that the bill simply then just defaults to whoever that substituted decision-maker is under state legislation, and if there isn't one, that people must go through the state legislative process, which has all those checks and balances?
That's correct.
Or is it a parallel process?
That where there's substitute decision-making, that needs to be notified to the department, and the state and territory arrangements that are in place are effectively the default arrangements that will apply in aged care, unless there are circumstances that suggest that that person shouldn't be the substitute decision maker. And that might be where, for example, an advocate has come forward to the department and said that that arrangement isn't working appropriately at the state or territory level, there's evidence of elder abuse, and in those circumstances someone else may be appointed for the purposes of aged care. But that is exceptional circumstances.
Yeah, because I think, if I understand correctly, some of the concerns that providers in particular have raised is that they feel like it's creating grey areas around when state law is overridden, and that makes it very difficult then, you can imagine, in a situation of crisis in particular, when there is then one person saying, well, the Commonwealth says I get to be the decision maker, someone else is standing there with a guardianship order saying, but I've been given decision-making ability. So what happens when there's a conflict? What does a provider do in that situation?
So the very reason why we have these arrangements codified is so that those circumstances don't occur, and it's always clear who is in that position with that legal decision-making authority. At the moment, there is a grey area because there isn't a codified mechanism for everyone in the aged care system to know who is appointed as someone's substitute decision maker. We did hear that feedback during the consultation process that the arrangements we had in the exposure draft weren't consistent enough with state and territory laws. And since that time, we did work with the jurisdictions to make some changes to ensure that the arrangements work in a much more harmonised way.
Is there a plan then, if this comes into effect, to have some fairly clear guidance and education for people? Because I think, if nothing else, what's come out of the hearings then is that's not clear to people in many instances, because it wasn't just one state where we heard that, and we also heard concerns raised by some of the legal, community law type advocates as well.
So Senator Greg Pugh, First Assistant Secretary of the Reform Implementation Division. That is absolutely our intention. So what we're going through at the moment is a process of developing our operational policy and guidance. We really want to remove any of those concerns or confusion around how that supported decision-making framework in the bill operates. So a number of actions that we're taking as part of that will be providing guidance and education on the appointment of decision-making supporters to confirm their scope of authority. We'll be confirming the policy parameters around those appointments and including what the role of the system governor, aka the department, is in that arrangement. Developing some of the operational policy that we really need to make sure that supporters can manage and avoid conflicts, and also detailing some avenues for reporting concerns and complaints regarding potential non-compliance for those people in the execution of their duties. So we completely recognise and agree that that operational policy and guidance needs to be developed, and that's what we're working on at the moment.
In relation to the system governor making those decisions to appoint supported decision makers, one of the concerns that was raised, certainly in at least one of the hearings by some of the lawyers, was, well, at the state level, that often involves hearings, to actually determine who the best decision maker is, evidence is tested, etc. Is it proposed that there will be that sort of process with the system governor, and will it be appealable?
It's definitely reviewable. However, we expect that those state and territory arrangements for appointing someone will operate, so that the system governor doesn't need to routinely appoint someone to be someone's representative. It's only in circumstances of an emergency where there is no one in place where the system governor would step in and appoint someone, and it would only be for the most limited time necessary until a state and territory arrangement is put in place. So it's not expected that we would have a dual system of resolving disputes. That's expected to take place at the state and territory level.
Okay, thank you. Moving on to the service lists, which I note that we had those, the rules coming out in relation to them, I think after we spoke to you the first time. We've certainly heard, or maybe just to go back to the beginning, is it the case that one of the goals of this reform is to have people ageing in place at home for longer?
Yes.
So that being the case, we've certainly heard a lot of evidence from both older people on lived experience panels, advocacy groups for older people, and also some service providers who've certainly expressed concerns around the caps on cleaning and gardening, insofar as that will actually lead to people not being able to stay in their own homes. So, for example, one of the things that we heard was if you have an older person who has respiratory illness, COPD, for example, then having a very clean home is actually integral to them being able to remain at home and not having to go into care. And we heard evidence that 1 hour a week would be very insufficient for many people in order for that to happen. We also heard about concerns around gardening and the fact that if lawns become overgrown, then we have situations where older people who are renting may in fact be subject to eviction because their yards aren't being maintained to a standard that their landlords and agents deem acceptable. We heard that it could lead to risks of things like snakes and the like being in yards, and we also heard about the fact that it just poses a safety risk in relation to mobility if those things aren't being attended to. So I guess what I'm keen to know is what consultation happened around the decision to introduce those caps at those levels, and how flexible is the department in relation to those lists as they currently stand in the draft rules, given the amount of evidence that we've heard that those things are going to cause real issues for many older people to be able to actually stay at home and age in place.
Senator, Nick Morgan, Assistant Secretary for the Supported Home Reform Branch. Look, for the caps on cleaning and gardening, just worth just pointing out quickly that The caps do only apply to cleaning, not all of domestic assistance. So just to be clear, that laundry services and assistance with shopping are not picked up under the caps.
Sorry to interrupt, but we heard very clearly that 1 hour a week, I mean, just any normal person, I don't know about you, I can't clean my house in an hour, and we heard that that poses real health risks for people, things like mould as well, dust, really concerning.
Mr Morgan.
Yeah, the caps were proposed to ensure that sufficient budget is being retained for services such as personal care, clinical services and the like, and that we were avoiding too much of a person's budget being loaded into cleaning and gardening services. So that was the broad intent. Those rates were selected based on really what was seen as a reasonable amount of cleaning and a reasonable amount of gardening. So, you know, a couple of hours a fortnight of cleaning was seen as meeting a reasonable community expectation of what cleaning service would provide. An hour and a half a month for gardening, where it might be more in the, you know, less in the winter and more in other months. Was seen as what would be a reasonable expectation. That said, since the rules
grow in Queensland,
Senator, it's very hard on video when we're interrupting the answers because of the delay. So if we could just let Mr Morgan finish. Thanks.
Sorry, Chair.
Thanks, Senator.
Yeah, look, that said, we've been receiving similar feedback to the feedback that the committee's been receiving on this, and so, you know, this the rules have been published. You know, with the opportunity to collect feedback and for the government to, you know, look at it when it comes in. So that's kind of that's how we got to the rules in the first place, I guess.
Yeah, so my question is, is it flexible? Is the department open to potential changes there? Because you also said that in your answer that the thinking behind this, when it was originally the caps were placed, was to leave room in the budget for clinical care and other care, and yet what we've heard pretty strongly, I think, in the evidence is that if you actually want to reduce the amount of clinical care, then for someone with a respiratory illness, for example, then you need to keep their house really clean. And I guess the point that a lot of folks were making was there's no point keeping money back for clinical care if you're not doing the other things, because what you're actually doing is putting people in positions where their health is deteriorating and therefore they need clinical care, as opposed to actually having a strong prevention focus.
Senator, if I just to reiterate that, you know, Mr Morgan's given you a bit of a community standard kind of argument that we turned our mind to in the development of those caps. I think we've heard, like you have heard, the concern from some of the witnesses to the inquiry. It's not a decision for the department to take to change that. It's a decision for government. But I think, you know, look, we understand the argument you're making. This is how we came to it. There's been a long debate for example, around gardening, about whether we're trying to, you know, help somebody maintain a meticulous garden or we're trying to maintain safety, and those are two different standards. And the cap represents what we think would help safely maintain a garden, but acknowledge we don't want to re-prosecute. Acknowledge the arguments that witnesses are making about that and cleaning.
Senator, at this point, I need to rotate, but I'll come back to you for another block. I'm going to block of questions.
Thanks, Chair.
Then I'll come to Senator Ruston. I just want to ask you about consultation on the rules. How is consultation going to be conducted, and how is feedback going to be considered?
Maria Filato, Acting Assistant Secretary for the New Aged Care Act Transition Branch. The public consultation on the rules is a valuable opportunity for everyone to develop a better understanding of what those changes mean for them, what they need to do and when they need to do it. More importantly, it should help unpack how the rules impact older people and the quality of care they receive, in addition to ensuring what we've heard from the sector in previous consultation has accurately been represented in the rules. It also provides a forum for providers to tell us what the new Act will mean for their business and what they need from us to help prepare for the implementation of the new Act from 1st of July 25. We will consult with the sector on the rules to test how things might work in practice and to ensure we understand and take into consideration any concerns. All rules will be consulted on before they are tabled in Parliament. There will be consultations held to collaborate and work with aged care stakeholders on the rules and get their input to the drafting on the rules, as well as after the drafting is completed to seek feedback on specific aspects. We will publish a timeline for the planned consultations. As much as possible, we are going to streamline and have a coordinated approach for the consultations for the sector. The consultations will comprise targeted forums with selected stakeholders, which we group by topic themes or stakeholder interest, webinars and Q&As, surveys to collect feedback on specific questions and invite submissions, and there'll also be communication to promote the consultation opportunities, and we'll also follow up on the outcomes. In terms of how we're incorporating feedback, we'll be considering the feedback received to further inform our policy and legislation operational details, and we'll share what we've heard with the sector in a summary on the website so that they understand how we've used their feedback.
This is an issue which has been raised in our hearings to date, as you would have heard in the evidence from various witnesses, including providers. Can I ask, in terms of the policies proposed to be contained in the rules, which of those have already been shared or been made available, and when were they shared?
Yeah, so we've made the service list obviously was made available at the beginning of October. We also published a summary of the rules on the 11th of October. At the previous hearing, we talked about there were a substantial amount of the rules are actually existing already, or mostly existing, partially existing as part of the current legislation. So, for example, if we look at, say, the Code of Conduct and Banning Orders, they've been in effect since the 1st of December 2022. We don't expect to be making any significant or any real changes to those. Things like, ANAC has been in effect since the 1st of October 2022, SIRS since the 1st of April 2021. In terms of things that we have that are kind of new, but we have consulted on the strengthened quality standards. So we published the draft final of that in November 2023. And likewise, on the new regulatory model, we started with a concept paper in February 2022 and have released a number of consultation papers since then. And we've had a paper online from December 2023, which provides details of the model that's going to be implemented.
I want to ask you about the transition to the new Act for aged care providers, and I'm interested in the work you're doing with those providers on transition. And also, there's been a huge amount of change in the sector in response to the Royal Commission into aged care quality and safety. As you assist with those things, what lessons have you learned about how the sector responds to change and how this should inform that transition?
I might start, Chair, and then...
Sorry, it's a big question.
Mr Pugh might add. I think there has been a lot of change for the sector post the Royal Commission, and, in a lot of cases, there's been a large amount of extra investment made, but a commensurate amount of responsibility for managing that change on providers. And look, to be honest, at every stage of the process, providers have advocated for a delay in the start of each measure, whether it's 24/7 nursing or care minutes or the like. And in a way, that's not surprising because people do not like change, and in many cases it's a difficult hurdle to meet. I think the current set of changes, it's important they've been framed in a discussion at the aged care task force where everybody's had to compromise, and so while providers would like more time to deal with the changes they need to make in this tranche of reform, consumers have been equally eager to see the benefits of the new Aged Care Act and the new Support at Home program come into being. And so, that's necessarily involved some level of compromise between different stakeholders. That all said, I think, the evidence is clear from providers. They are anxious about the changes that we are seeking to make and to have the Parliament consider. And it is clear when you hear evidence from particularly smaller providers or people outside capital cities and not necessarily peak bodies that people are anxious about the detail of what we're trying to do. And so we have an obligation, the department does, to work harder, to communicate better and to get into that detail and satisfy their desire for knowledge around these particular operational policy details which are incorporated in the reform. And we recognise that. I think it's been clear in the evidence given, and we understand that we've got a challenge to meet that, and we're fully prepared to do that. I might get Mr Pugh just to kind of talk through the sub-strands of work that we've got to do.
Sure. So we recognise, as Mr Lai says, that this is quite a large reform agenda, and we do have a pretty short runway between now and 1 July 2025, but the way that we're best mitigating against that is to just break down all of these elements into workable pieces. So we've got an overarching implementation readiness framework that sits above all of our projects, programs and policies, and that splits it up into the strategy layer, the monitoring layer, the schedules layer, and also the tools to support that implementation. So within each of those layers, you've got a whole range of critical paths if it relates to ICT. You've got a whole range of communications and engagement products if it relates to that element of implementation. And we've also got basically like a reform pipeline that shows the magnitude of change coming down over the next sort of 8, 12, 24 months out through till 2027 when we're rolling in CHSP to support at home. So when you do have that framework in place, we have a whole range of governance structures that sit underneath it. Probably two elements that I'll pick up on in particular. One is around digital. Digital is obviously one that requires the longest runway, so we're doing a lot of work around that to make sure that we've got those digital elements in place to support the aged care reform agenda. We're going through a scoping and sequencing prioritisation process, and that will help us chunk down what system changes are released over the next 3 release cycles that we have between now and 1 July 2025. And we're also working closely with our external partners, so National Aged Care Advisory Council and the Council of Elders. We've got digital specific sector partners and tech talks that we go and we co-design some of these systems changes with, and we're close to actually having our digital roadmap ready for release. So I think at the start of next month we'll have that roadmap ready to go, and then our external partners can start to adopt and pick up those things. I think just final point, you asked about lessons learned around communication. So what we learned over the last couple of years, particularly since the Royal Commission report was handed down, is that people are really, and providers in the sector and consumers are really keen to understand what the changes are when they're coming and what that means for them. So to that end, we've released the reform roadmap that's updated quite regularly as decisions of government are taken. And we've also undertaken a large number of webinars that happen pretty quickly after decisions are made public to get that information out to the sector, and also initiated other communications channels, including the Your Aged Care Update newsletter, which has got about 40,000 subscribers. And we're also working through the sector-specific comms products, manuals and handbooks and the like. So there's a lot in there, but we do have it all structured neatly around this implementation readiness framework.
Okay, thank you, Mr.
Chair, I mean, digital is a great example where we've been doing a lot of work for a long period of time, and we've co-opted a lot of people in the sector to be involved in that, and certainly larger providers who've got a better capacity around digital, have been actively engaged in that. But I think it's fair to say that now smaller providers are turning their mind to what's the software requirements for 1 July next year, what are the things I have to do, and we've got to work doubly hard to reach that group of providers now with very specific advice and information to help them get to the finish line of 1 July. And those are the people who I think are more likely to be sort of saying, I'm anxious about what changes I need to make and how I'm going to do that in the time frame.
Yeah. Thank you, Mr. Lai. Just one more from me before I pass the call to Senator Ruston. Providers raised concerns throughout the course of our inquiry that under clause 547, aged care workers are included as people who can receive protected disclosures under the bill's whistleblower protections. What's the department's response to those concerns raised?
Thank you for the question. In considering the whistleblower framework in the bill, we did look to other frameworks, including the public interest disclosure for public servants and the corporations law. NDIS also has a whistleblower framework. We purposefully made those categories of people who can receive disclosures broad, and the reason for that is that vulnerable older people may not necessarily know who they have to make a disclosure to in order to get protections. So the intent was that we would keep those categories as broad as possible to ensure that the broadest possible scope of disclosures would receive protections as whistleblower disclosures. Having said that, we have heard that feedback through the inquiry process as well. There is a balance to be struck between clarity and ease of administration of a whistleblower framework and protecting a broad range of people who want to come forward with information. So, yeah, we have to try and strike that balance.
Okay, thank you. Senator Ruston, you have the call.
Thank you. Can I just sort of get a clarification on a couple of the answers that you gave to Senator Smith and Senator Allman-Payne? In relation to Senator Allman-Payne, just you made the comment on a couple of occasions, we turned our minds to the caps. I'm keen to understand why you only turned your mind to caps on gardening and cleaning. In Mr Pugh, you made the comment that it was cleaning only related to cleaning, it didn't relate to laundry or anything else. So keen to understand why you only turned your mind to caps on 2 items on the list.
So I might just have to defer that question
Sure.
to Mr Morgan, who was involved in that conversation.
So, Senator, can we just clarify what you mean by the question?
Well, you, I think actually it was you, Mr Lai, who said we turned our mind to the caps, and yet in the service list that I've seen, unless there's an updated one, there appears to only be caps on cleaning and gardening that are contained in the information I've received, not caps on laundry or any other aspects that are contained in the everyday living services
So in the
list.
policy process, we looked at the issue of having caps, and those are the 2 areas where I think, as Mr Morgan said, there was a concern that they not be, overconsumed at the expense of, say, clinical services within a package.
So, but I mean, my question is, why didn't you think that doing somebody's laundry or, any of the other elements of the package?
Well,
and I suppose the other question is, who decided and what was the basis on which you decided on those numbers?
Well,
Who did you consult with? How did you model it? What evidence did you take? How did you come up with those numbers?
Yeah, well, I think we tried to give you a sense about that community standard, which is what we drew on, and the overall package design was a decision of government.
Okay. To you, Ms Metz, in relation to the whistleblower questions just recently asked by Senator Smith, I'm just interested to understand, how much clarity do you think aged care providers and older Australians understand the difference between a whistleblower provision and a grievance complaint?
Yeah, it's a good question. The primary purpose of whistleblower protections is to make sure that people feel safe to come forward and make complaints. And we did speak to the NDIS Commission about this because they have a similar arrangement in place. So they have whistleblower protections as well as a complaints framework. The whistleblower protections aren't relied on very much at all when there's a whistleblower protections are there because people feel safe to come forward through the complaints process. It's really in circumstances where there is adverse action taken against someone after they come forward with information that the whistleblower arrangements kick into effect and protect that person from that adverse action.
Yeah, certainly understand the process, but I'm just trying to understand why it was a very broad definition of the kind of people who you were suggesting would be able to take those adverse action complaints, which we're talking about pretty serious complaints. They've either got to be illegal or unethical. We're not just talking about somebody who doesn't like something or they feel like they haven't been treated very nicely. We're talking about potential legal action and even the invoking of the criminal code in other legislation by some of the things we're talking about. So I'm just trying to understand why you would have such a broad, what brought you to the decision to have such a broad range of people who would necessarily need to be trained in taking these sorts of complaints, because they are quite serious. It's not just like saying, you know, my bath was too warm this morning. So I just wanted to understand the process of why you would think that everybody who worked in an aged care home or in aged care for that matter, you know, and what sort of cost did you put against having every single employee of who provides aged care being in a position to understand what their obligations were in relation to taking those protected statements?
There's a few questions in that. I think I've probably answered the question as best I can around the reason why we chose broad categories, and that's to ensure broad protections. But yeah, acknowledge that there's a balance to be struck there. People need to understand whistleblower arrangements and understand when they're getting a disclosure and what that means. When we spoke to providers about this, many providers said that they already have whistleblower arrangements in place or complaints frameworks. So we didn't consider that there would be any particular cost over and above what providers are already doing to put whistleblower arrangements in place.
Well, can I suggest that if you'd actually bothered to consult with the providers, that you'd probably find that they are very, very concerned about the cost and also the burden that they may place on employees that aren't necessarily highly trained within their workplace. You know, it could be the cleaner, it could be somebody who's providing domestic services, it could be somebody, you know, who was in the kitchen, because your definition allows for the scope of people that maybe if you asked, you would have found that there is a great deal of concern. And as you would know, you've been watching, I'm sure, the hearings as they've been going on. It seems to be very regularly raised. Yeah,
it has been raised through the hearings, and we're definitely keeping that in mind when we're considering how to go forward with this.
There could be
It wasn't something that came up very strongly through the initial consultation that we did on the whistleblower provisions. It's something that has come up much more recently. And as you've said, whistleblower disclosures relate to very serious conduct. It's not just, I don't like someone or they've offended me. And so I would hope that all workers in an aged care environment, if they are receiving a serious disclosure, have some knowledge about who to report that to, what to do with that information. So, yeah, I take it that, take the point that, you know, these arrangements are new and they're called whistleblower arrangements, but I would expect that training already exists about what workers should do if they receive information that's very serious.
Okay. Thank you. Almost to a T, the biggest issue that has been raised is the concern about the lack of information in relation to the rules and therefore a lack of understanding from providers, particularly around support at home, but more generally, about what expectations there are in relation to the costs that are likely to be incurred, when they can start making changes to IT, staff training, etc., etc. Just about everybody was concerned about that, including some of the advocate groups and the consumer panels that we've spoken to. So the first question is, when will we be seeing the subsequent tranches of the rules? We've seen an overview of Chapter 4 rules, so thank you for that. When will we be seeing the Chapter 4 rules, and when will the subsequent tranches of the rules in relation to the other chapters of the bill be available for public consumption?
So, as I said, we've already tranched out the rules and provided that information to the committee. We're currently in discussions with the Office of Parliamentary Counsel about aligning those tranches to particular timeframes so that we can give that specificity to the sector. So I would say that will be coming soon. We'll be able to provide that to the committee, attaching dates and timeframes to those tranches.
Within the timeframe of the committee's deliberation?
I'm trying to look at the date.
31st.
Our best endeavours. Yeah, we'll do our best.
So the question has got to be, what consideration has the department given to these really very valid concerns? And you know, I heard you say people don't like change, but people also don't like uncertainty, and there is a massive amount of uncertainty now. Whether that is because we haven't consulted enough with them, whether we haven't provided enough information or detail, or whether simply the detail hasn't been provided yet, that's a matter for you to determine. But it seems to me that we are asking for a massive leap of faith by everybody, you know, people who are beneficiaries of aged care services, the aged care providers themselves, the employees that work in an aged care setting, and the families of people who are receiving aged care services. Huge leap of faith to go from where we are at the moment to where we need to be with this bill in the absence of this information. So I'm keen to understand, you know, we've been talking about this for quite some time, and we're sitting here nearly at the end of October. We still don't even know the timetable of when these rules are going to be made available. Do you think it's reasonable for the sector to be marching forward with this in the absence of the information that they so clearly need?
Senator, I think there is people have come to understand in the public debate that there's this thing called rules and they want to see the rules, and I appreciate that. I think what Ms Laffin has already outlined is, in a great many cases, the policy that underpins what the rule will look like. The rule is the statement in law of the actual policy. The policy has been released and consulted on, and people are now, I suspect, there is some confusion about the difference between the rules and what they've already talked on many different occasions about, which is the policy substance. Now, that doesn't remove our need to give them that ability to look at and discuss the rules before 1 July next year. We appreciate that. But I think there's a difference between that and not knowing what the actual policy is, because in many cases what is being put forward to them is not new, and indeed where it is, they've already been able to digest the detail. I think the issue which we appreciate is we need to get into a discussion with particularly our providers around the operational policy, and not the rules, the operational policy about how things are going to work, and make sure we get them to a level of comfort that they're currently not at. And we do, like that evidence has been clear before the committee, and we appreciate that, and we've got to get the timetable out to them, and we've got to get into discussion with them and make sure that they feel more confident about 1 July than they do today.
It's particularly relevant around support at home because it's new.
Yes.
And I think, you know, in terms of RAC, it's probably not quite the same level of concern, but certainly when it comes to support at home, there's a huge amount of concern about how it's actually going to operate. I mean, things like, for instance, has any consideration or any modelling been done to understand what the additional exposure to unrecoverable debts, I won't call them bad debts for obvious reasons, but there often comes a situation for debts that are very difficult to recover because of a circumstance. Has there been any modelling or understanding done around the additional cost or liability that potentially could fall onto providers because of the additional amount of consumer contribution that's being asked, because bad debts largely fall on the providers now. And Mr Hartland, I see you've come to the table, so clearly eager to answer. So has any modelling or do you have any idea about the likely increase in risk of bad debts on providers from the changes that are being proposed?
Thanks. So Nick Hartland, Special Advisor. So Mr Morgan and I have talked to providers a couple of times about this. You won't be surprised to know that they've raised it with us also. So we've asked providers to quantify the impact at the moment, but we haven't got anything back from them as of now. Now, they've not given you guys anything? No. So we suspect on that basis that it's actually probably quite small, the bad debt problem.
Sorry,
but
what did you say?
We suspect that because providers haven't quantified it and provided information to us, and we've asked a number of times from a number of providers who have pretty well set up information systems to quantify it for us, and we haven't received any information about it. So we suspect it's actually quite small, but if there are providers tuned in that have that data, of course we'd be able to consider it.
They spoke to the hearing. We've had a number of them raise the issue.
They've raised it, but they haven't quantified it.
Yeah. Okay. One of the things that did come out of it was particularly around if a miscalculation or the like has occurred through Services Australia, as opposed to a situation where somebody passes away and it's difficult to pursue an outstanding debt under those sensitive circumstances. Is there any provision at the moment, and is there any proposal for any provision, but if it can be identified that it was actually an error done by Services Australia or some government instrumentality, that bad debt or the risk of that bad debt doesn't sit with the provider?
So in supported home design, there's some structural features that should minimise that. So if there's a change in circumstances that results in an increase in payments, then that will only be applied from the next quarter. So that would certainly minimise cases where a provider would need to go to a participant, and those cases wouldn't necessarily be, sorry to clarify, that would be a wider group than errors by providers. I mean, there are existing procedures under all Commonwealth legislation that if the Commonwealth makes an error, that it can be considered that the debt is waived or written off. But I probably have to take on notice unless Ms Laffin or Ms Metz have that at their fingertips, the circumstances where that occurs. But there are provisions that allow for debts to be waived or written off, provided they meet certain criteria under legislation.
Yeah, sure, that'd be great. A bit more information on that. Thank you. Another issue that was raised throughout the hearings was around the inability for additional service charge or extra service charge. Every time you keep changing the name of it, it's something service
Extra
charge.
services.
Extra services.
Or higher.
Higher services charge, not whatever word you want. The requirement that you couldn't actually ask somebody to sign up for additional charges until after they'd been accepted into the aged care home. Concern was raised around the inability or the likelihood for new builds that providers are likely to make decisions as to not put in particular services and amenities that they know that many people are likely to want, simply because they've got no certainty in terms of the ability to be able to recover those costs. And it was also suggested through that process that it was actually taking away the rights of older Australians who have the wherewithal to be able to pay for additional services. And I think one of the ones was a hydrotherapy pool or those sorts of things that were built into the capital construction of a home, that they were questioning why there was a need to take away that right of an individual to make those decisions on their own behalf. I want to go into that particular aged care home because it's got this, that and everything else that I want to have access to, and I'm happy to pay for it. Why is it that they can't make that decision?
I mean, I think there's a whole... Certainly it's not... we can't see a circumstance where it takes away the right of someone to purchase those additional services. The material change is that there's a cooling off period for these types of services, so people can understand more what it is they're purchasing by having a period of time in the facility, and that's a bit similar to the provisions that apply now to the choice between accommodation payment mechanisms. And the idea behind that, it came out of the task force.
That a bit for me? I didn't understand what you just said.
So at the moment, with the choice of how you pay for your accommodation,
So you move between a RAD and a DAP.
I'm saying there's a precedent in the system for a cooling off period, I think is the essential
You've
point.
just opened a can of worms about
Well,
the DAP, but anyway, keep going.
Yeah. So there's a precedent in the system for that type of approach. This idea of a cooling off period came out of the task force report, and it was felt that there needed to be additional protections in relation to additional services. There's a body of work being done to simplify the arrangements so that they're more transparent. And I think just going to the thing about the hydrotherapy pool, which I do find maybe confusing. So at the moment, if that was paid for by additional services and a person, for example, couldn't use it, then under the existing laws, a provider ought not to be charging them for it. So I'm not sure what the basis of the hydrotherapy example is demonstrating.
Well, I think the example is that if when you choose to go in there, you say you're not using the services of the hydrotherapy pool, it creates greater certainty. The other choice is that they may, obviously the aged care home. Okay, so let's move on to the other side of that.
So now I'm about to pass the call. Is this on this topic or a new topic?
Oh, I've got ours on this topic. So,
yeah, that's
so
fine. I thought if you're wrapping it up, I'd stick to the question, but if not, I'll rotate the call and come back to you. So Senator Allman-Payne.
Just a clarifying question, actually, in relation to the line of questioning that Senator Ruston is on at the moment. One of the things that we heard in the evidence to date from providers is that they have concerns around not being able to raise any of those additional services prior to someone entering a facility. So you've talked about the cooling off period, which seems, reasonable. Someone makes a decision and then they don't want it. But they talked about the fact that, in their view, they can't even raise with people before they enter the facility, what those, give them a menu, for example, of what all the higher services are. And there was concern expressed around the fact that, well, how do you make a decision on which facility you want to use if you're not even across all of the potential services that you might be able to access? So just wanting to clarify whether that is the case, that they are barred from raising that and providing lists of additional services to folks, or is that a misinterpretation on the part of the providers?
I'm always reticent to characters' misinterpretation, but I think it's wrong. One of the aspects of the reforms and the protections that we want to put in is that providers are required to give clear information about the goods and services they offer and a price schedule on My Aged Care. So we would have said that one of the things we're trying to achieve out of this reform is to make it clearer to people before they enter what providers offer as additional services. And that's got that information that they should offer to people, and also we're working to clarify the list of specified services and goods and services so that people are clear about what the government is purchasing on their behalf.
Yeah, because obviously there's a balance, right, between not having people feel pressured into taking services that they don't want, but the concern was just around, will people be able to understand everything that's available to them, notwithstanding that they may not want it. So I think that's helpful in your response. That's all I had, Chair.
Did you want to put your questions for the Commissioner now as well, Senator Allman-Payne, because you still have the call for this block?
Yeah, that would be great if I'm able to.
The Aged Care Quality and Safety Commissioner.
Oh, sorry, the First Nations.
Oh, First Nations Commissioner. Okay.
That's correct, isn't it, Senator Allman-Payne?
Yes.
Yes. No. Unless she's... Hi. Senator Allman-Payne, we're ready to go. Ms Kelly's at the table.
Thank you. Thanks very much, Ms Kelly. My question is more general in nature. I'm just very keen to get your thoughts on the legislation or the bill as it is before us, and whether you have any concerns about any of the provisions and the way in which they might adversely impact First Nations people or First Nations older people.
Thank you, Senator, for the question. I've been working closely with the department around a number of concerns that older Aboriginal and Torres Strait Islander people and their families have raised with me, particularly around the aspects of cultural safety, the system being complex, hard to navigate, and specific areas around their connection to country, wanting to stay on country. But I'll continue to work with the department on those matters, and and certainly make sure that those voices from the Aboriginal and Torres Strait Islander community are captured in, whether it's the legislation, the rules, or the policies that underpin the legislation.
Could you maybe expand a bit more then on the concerns that First Nations people have brought to you?
Yeah, so certainly, Senator. I conducted over 135 consultations nationally, met with around 1,000 Aboriginal and Torres Strait Islander people, but including mainstream peak providers, peak organisations and mainstream providers as well, just to understand what Aboriginal and Torres Strait Islander people are experiencing in the aged care system, and making sure that we get the system, improve the system and the access to the system. That's been one of the biggest challenges, is people's ability to access the system, the difficulties in navigating my aged care, the complex nature, and just the communication and information that Aboriginal and Torres Strait Islander people, receive in terms of the current aged care system. So, as I said, cultural safety and feeling safe in the environment. People are particularly want to stay at home. They don't want to go into residential aged care, and that's particularly true for stolen generation survivors, veterans and members of the LGBTQI community who I've met with, residential aged care and the trauma of being placed, into going into residential aged care. So again, looking at their unique needs and specific needs. What else?
Can I ask in relation to that then, given that, because we certainly heard from some other witnesses in the hearings process to date too, that, folks who have experienced previous institutionalised trauma are very, very reluctant to go into a residential aged care facility. So have there been conversations around, because I would imagine if you've got someone who's experienced trauma in that context, it opens up the possibility that somebody might actually need quite a bit of additional services in the home if they can't access them in a residential facility when they get to the point where they have high needs given their trauma. So are there discussions going on, for example, about where the mix, for example, because we've heard in earlier evidence today that, for example, caps on cleaning and gardening, part of the point of that is to preserve more in a package for clinical and other care. But have there been discussions, for example, around whether or not a First Nations person or someone else who's experienced trauma who can't go into residential aged care for that reason might actually require additional services beyond what a standard package, the highest level package would be?
I have had conversations with some of the Stolen Generations organisations. The overwhelming support that they're seeking is really around being cared for by those organisations, the people who know them, which could look like care homes, group homes, where they can live together and be supported to live together. Again, they're matters for the department and the government, but that's certainly what people are telling me. And I think if we extend that not only to the Aboriginal and Torres Strait Islander community, but also other Australians who through the sexual child abuse, they'd be experiencing the same sorts of trauma. So again, while my conversations have been specific with Aboriginal and Torres Strait Islander people, I think that model of care we need to think about for all Australians who've been traumatised through institutions.
And given the nature of some of the places in which that care would be required, is it your view that is best provided by government services or private providers, or it doesn't make a difference?
The Aboriginal and Torres Strait Islander people have told me they want to be cared for by their community organisations. They want to be cared for by Aboriginal and Torres Strait Islander people. So, that's what they want. That's what they want to see out of the system.
Senator,
Thank you.
If I can add, we have worked hard to try and lift the capacity of the mainstream residential aged care sector, particularly around trauma-informed care. But our First Nations people do not choose to access, for the reasons Ms Kelly said, residential care predominantly, but they also want Aboriginal controlled services, Aboriginal managed services. And so we've been doing some work with an organisation in South East Queensland to work with ARCHOs, with Aboriginal community health organisations, to train to become aged care providers. And that we have now for ARCHOs across the country who have reached a point of accreditation, ability to provide aged care services. But the dominant mode in which they're providing that is home care, is care in the home, and not a residential service. And I think we have to be pragmatic about the fact that while it's important to lift everyone's capacity, we need to concentrate on the development of more access points for Aboriginal people to community-controlled services.
All right, thank you. Thanks, Chair.
Thanks, Senator Norman-Payne. I'm passing the call back to Senator Ruston, and then I'll be going to Senator Pratt.
Thank you very much. Can I just go quickly, just get a bit of updated information on home care waiting lists?
Hi, Senator. Thea Connolly, First Assistant Secretary, Home and Residential Division. I'll just open up the latest information, if you'll bear with me. I can tell you from memory that at the highest level, the current wait time for home care packages across all levels and all priorities is 5.5 months. That's the average across everything. For high priority, people who are waiting on a high priority, they're currently receiving their package within 1 month. That's remained consistent over the last few months. For people who are on a medium priority package, currently on average taking 9 months to receive their package.
Okay, so what numbers have we got on the waiting list at the moment?
That's the number I just need to look up, won't be a second. System has frozen, but I believe as at 30 September, it's around 76,000 people on the national priority system, but I will just need to double check that when I can.
Okay. And can you, is that 76,000 on the waiting list, or 76,000 people who aren't receiving the care, the package to the level of care that they have been approved?
So that 76,000 are people who are on the priority system waiting for the package that they have been assessed for. Of those, as we've discussed previously, many of those are already receiving a package, but just not necessarily at their approved level of care, or are on the Commonwealth Home Support Program.
The majority of them being on CHSP?
The majority have been approved for Commonwealth Home Support or are already receiving a package. I think 99% of people.
Yep, okay. So do you, in terms of the wait list that you were talking about, I'm keen to understand level 1, 2, 3 and 4, but also what is the wait list from when somebody applies for an ACAT assessment to when they receive an ACAT assessment to when they get their package? So I'm assuming that those numbers that you gave me a minute ago were from assessment to receipt?
That's right.
So do we have the wait times for application to receiving assessment?
So that's not a single number, Senator. So that will vary across the country. Where the National Prioritisation System is consistent across the country, it's designed to be. The wait times for an assessment vary by jurisdiction, and so the wait times will vary across each of the jurisdictions.
So do you have a median and the outliers on that wait times?
I can get the assessment performance as at September. Okay. For simple assessments, so for people going into the CHSP, the median wait time for 23-24 was 15 days. That's
How long?
referral. That's for referral issued to assessment completed, 15 days for the simple assessment. So for people who are going into the Commonwealth Home Support Program.
Yep.
That's the median. The average is 19 days. For complex assessments, so ACAT assessments, which is into a home care program, we have different data for in community and in hospital. In hospital, it's much quicker to receive your assessment. Typically, within 1 day is the median wait time. In community, it takes 40 days. Is the median wait time. That's across 23-24.
Okay.
And then across both of those, then the average is 22 days.
Okay. Of the 24,100 new home care packages that were announced in the budget, how many of them are on the ground?
I'll take that question on notice, Senator. I'll see if I can get you an answer today. I know that they have commenced being released in July. I understand they're being released in a linear pattern, so at least a quarter. But I'll need to just confirm the exact number for you.
Okay, thank you. I'm just wondering, a couple of our witnesses, including Professor Eager, who I understand has been involved quite a bit in terms of providing advice to the department in relation to ACAT, including ANAC, to aged care, including ANAC, was particularly scathing about the savings that were being predicted or projected by these reforms. And I was wondering, has there been, what was the modelling that underpinned the decision around these savings? Because, as I say, Professor Eager she went into quite a lot of detail around how she made an analysis around the numbers that she'd seen in what had been reported in the papers, and she was actually even only going on the net figures, not the gross figures, because we know that the net figures that were quoted in the paper of $12 billion it was, were net figures, so the gross figures are obviously significantly higher. She asked some very fair questions around the modelling that was undertaken in order to determine those figures. Is there any more detail that you can provide us in relation to that modelling?
Well, I can tell you about the approach to modelling that we use, which in residential care and supported home is somewhat similar, though they're different databases. So in residential aged care, we hold a database that we've put together of every resident in the system and their assets, and with an attribution in some cases, but with actual data on their assets and income. And so we're in a good position to model precisely what a change to means test assessments will have for residential aged care. In supported home, we also have a unit database that we have to make more assumptions on in relation to assets, because at the moment we don't hold that information, but we've got a database where we can look at over time estimates of people coming in, the average income and assets that people have, and therefore the effects that means testing measures will have of them. So in addition, both of those modelling are validated by our central agencies in the normal course of a costing and policy development exercise. So we're pretty confident that the models are sound and the estimates are robust.
We asked a number of the witnesses around any issues they thought that the quantum of the changes that were being proposed would be sufficient to actually sort of stimulate behavioural change in terms of the way people were behaving. And one of them that came up related to RAD. So, I mean, is it the department's view, is it the current view of the government as best you know, which I'm not asking you to make any policy statement on behalf of the government, but is it the view that a residential aged care room, or when somebody moves into a residential aged care home, that it is their home?
Yes, I think that our general view would be that if you enter residential aged care, then that's your place of residence, and there's a lot of policy around making that a home-like environment to ensure that people are comfortable. So
in a
yes.
technical sense, Senator, or, I mean, because to be fair, some of our Council of Elder colleagues would say the opposite. So there's different views. So some people would say no matter how home-like the environment you try and make it, that it isn't my home, it is a place that I've gone to. So there are different views amongst our stakeholders. But do you mean in a technical sense, or do you mean?
Yeah, no, I'm sort of more moving to a technical sense, because I mean, if you sell your home and move in, and because you're moving in and into an aged care home, in effect that, you know, this is your principal place of residence. What I'm trying to get to is that, do you think that the treatment of a RAD, which is obviously what you pay, if you pay for a RAD going into an aged care home, you sell your home, you pay a RAD with the money that you've sold your home for, but that's not treated as your principal place of residence for the purposes of the assessment of paying the means-tested care fee, and there is no proposal in this legislation, unless I've misread it, that should change. Is that correct?
So a refundable accommodation deposit has always been assessable in the aged care means test.
Has always been accessible?
Always been accessible.
So it didn't change in 2014?
You'd be taxing my memory. I suspect it was accessible for the assets test component of the pre-2014 changes, Senator, because otherwise the government would have paid accommodation supplement for everybody.
Well, according to the changes for Living Better, Living Longer prior to 2014, a refundable accommodation deposit was not assessed as...
Would have been accessible for the accommodation component. So they had they had a capital test. We might have to take it on notice, because I wasn't around, even I wasn't around in 2014, Senator. Immense apologies. But they had two tests. They had an income and a capital test, and the capital test applied to accommodation, income applied to care. They brought them together, but the RAD would have been always accessible, as I understand it, and I'd have to qualify it with again, that I wasn't around, for the accommodation component. So in broad scope, the RAD has
But
always
if
been
you had a
accessible.
RAD and you didn't have an accommodation component because you've got a RAD.
That's right. So you have to make it accessible, otherwise you would have an accommodation component. That's the issue with assessing the RADs. Exactly right.
Should we
No,
take
that's
it on
not
notice,
one.
Senator? I think
So-
rather than debate it, should we take it on notice?
Yeah, no, take it on notice only in as much as I'm just interested whether you had taken into consideration when, originally it was 17.5% was the taper rate as it related to the non-clinical care contribution. Obviously it's now 7.8%, but it's a significantly higher taper than the current taper when it comes to the means tested care fee, which is sort of 1% then into 2%.
Yep.
It's now 7.8%. Just interested to understand whether you've got a situation where the treatment of the refundable accommodation deposit was going to have a minimal impact on somebody's finances when it came to the assessment of the RAD. So, at 1%, there was $1,000 for every $100,000 would have been the treatment in relation to the means tested care fee. You're now proposing for that to be $7,800 for every $1,000.
But Senator, only over a certain range. So what someone ends up paying may not, depending on where they sit on those ranges, end up being hugely different in terms of the non-clinical care, because there's a lot of other things going on. Remember that the means tested care fee capped out at the total value of ANAC. So someone could end up paying $400 a day if that was their care component, obviously with an annual cap. So
I was going to say the annual cap's had a bit.
Yeah, no, I know you don't as well. Where that all ends up in terms of the actual impact on a RAD will depend a lot on the person's circumstances.
Yeah, absolutely. But I think, you can't really argue with the fact that no matter what the situation with caps that were in place at the time, an $80,000 cap to boot and $32,000 or $33,000 a year, we're now in a situation where if somebody, for example, has got they've paid a significant RAD and they're in that section of, $500 to $1 million where that whole thing takes place, you're talking about a significant increase for those people for those people that are paying RADs. And so all of us, it will make a very big difference to what RADs look like. So I'm just interested to understand, and the reason I ask you about behavioural change is because, this sector is heavily reliant in terms of its uplift in its bankability on RADs because of the retention that's been applied to them as was requested by the sector. I'm just wondering whether any modelling's been done as to what the impact is of the fact that because the RAD is actually taken as to be part of the assets test for the means testing for care, it's not assessed for means testing for the age pension, but it is assessed for care, whether that has been taken into account in your deliberations as to the likely impact.
Yes, Senator. We don't think there's going to be a major impact of that aspect on RAD uptake.
Oh, so the question then is, what kind of? I mean, what analysis have you done in terms of the savings that are applied to it?
It's built in. The impact on the RADs is built into the savings estimate. So the macro figures that you've referenced include an estimate of the impact of the new means test changes on people who choose to pay by RAD.
So I'd be really keen to understand what that number was.
I don't have that with me, but it's in the modelling. Yes, it's been accounted for in the modelling. Yeah.
Senator, at this point, I'm going to rotate the call, and then I'm coming back to you after that. Senator Pratt.
Thank you very much, Chair. I'm going to pursue some questions around co-contributions. I've noted that on the panels that we've had as a committee, particularly those commenting on their personal concerns and lived experience, have expressed potential fears around the proposed co-contributions. So I'd like an outline, please, of the protections that are in the bill or will be in the rules, and how the department is working through preparation to ease some of that anxiety?
Thank you, Senator, for the question. So there's a number of aspects to the answer. So the first one about working around the anxiety, we've talked just a little while ago, Mr Morgan and Mr Lisa talked about the process for what we'll do to communicate with consumers. In relation to protections, I think the first thing to say is there's very thorough grandfathering protections that will apply to these new arrangements, so people in the system won't see a change in their circumstances. In both supported home and residential care, there are protections built into the design of the new contribution arrangements. So in supported home, we've worked to make sure that the percentage contributions are reasonable. The process ties more to the pension system than occurs at the moment, so that it picks up the equity that's inherent in the age pension system. And in addition, contributions will be as a percent of the services that people use. And so that's a bit of a protection too, because at the moment, under the income-tested care fee, people pay the same fee no matter what services they use. So they can end up paying a very high percentage of what they've actually used. There's also lifetime contribution caps in supported home. In residential care, again, the design has caps on hotelling supplement and the non-clinical care component, so that they don't, the hotelling supplement can't be greater than the hotelling supplement, and the non-clinical care component's capped at at a level at $101.16. People won't be asked to pay a non-clinical care contribution after 4 years. There'll be a $130,000 lifetime cap on both contributions to non-clinical care and supported home, and RAD retention amounts are capped at 5 years.
Can I ask in that context, some people have been advocating before the committee to see the grandfathering withdrawn because some providers have been asking for that. So in that context, I think it's just important to be clear that you're restating the government's policy intent, which is to have that clear grandfathering provision. We've had some discussion about the supporter role already today. I'm keen to understand what you're doing to prepare the sector for that role. Comment on concerns from both the sector, that would be really helpful, and from advocates who are worried about how those supporter roles will be implemented in the context of, the kind of history that we've seen around powers of attorney and the like, that there's clearly been issues with.
I can start. Sorry, thanks, Senator, for the question. So probably just harks back to the implementation discussion we had a little bit earlier. So there's a lot of work underway to make sure that the sector is ready on all those implementation fronts, so policy, legislation, ICT, operation and sector readiness is obviously a big one as well.
Yes.
So we spoke through earlier around the need to have our operational policy guidance manual information out there as soon as possible. So we do have a bit of a job at hand at the moment to get that work finalised, and we really want to make sure that the roles and requirements of the supporter, the older person, the system governor, providers, there is absolute clarity on the process and that the sector is ready for change. I think Ms Metz mentioned earlier that CODA and OPN in particular had long been advocating for this change, so we'll continue to work with those organisations to make sure that it's done well. Probably just to go back over some of
that. That's not your problem.
Sorry, Senator Payne, you might need to mute. I think that's you. We can hear.
I was just trying to work out what was going on there. I think think Senator
No.
Orman-Payne's
So
on.
is the what time does the LAC finish today?
Senator Orman-Payne, can you hear me?
Just hang on a minute. Can you just wait? I have to get on the call.
Are we able to? No? Okay. Senator Pratt, if you continue, we're just seeking to contact
Great,
Senator
thank you very
Orman-Payne.
much. So, just as a further question to that, thank you for that answer. What engagement have you had with the states and territories in the creation of this role? How is it consistent with existing laws within the states that also need reform, and how will you move through that?
So following the exposure draft process, we held a workshop with the states and territories to work through particularly what some of their concerns were around how the arrangements are harmonised. I think it's important to note that what we're including in the bill provides clarity around what those arrangements are and consistency with other national legislative frameworks that give people rights and entitlements like the NDIS, Social Security and the National Redress Scheme. So the Commonwealth is very experienced in managing those types of frameworks. They're very common across the Commonwealth. There is broader work underway between jurisdictions, which is being led by the Attorney General's Department, to try and harmonise arrangements across the country. That work has been underway for some time.
Harmonise arrangements for what?
For powers of attorney and guardianship. Yeah. So at the moment we're working with each jurisdiction's different arrangement, which is why we need a consistent arrangement at the Commonwealth level. There's no national register at the moment or national arrangements. So until that time, in order to embed supported decision making, which has very strong support, and ensure that the will and preferences model is paramount, it's really important to include those provisions in the bill.
Okay, so for example, if someone had power of attorney over someone and you thought an aged care facility thought that perhaps they were subject to financial abuse from the person who held that power of attorney, and that therefore a different supporter perhaps thought that they were trying to minimise their use of the scheme or any drawdown under a RAD or a DAB or whatever they're called, in order to minimise the drawdown on someone's, potential assets, for example. Are these some of the kinds of scenarios that you've worked through?
Absolutely. There are lots of different scenarios that we've worked through in coming up with this framework, because those arrangements and family circumstances are very, very complex. And so the way that the arrangements work is that, in general, the state and territory arrangements operate, they're notified to the Commonwealth accepts those as being in place. But if issues arise, there is the ability for the Commonwealth to do something in circumstances where there is financial abuse or something along those lines. There are strong protections in the bill, obligations on people who take on that supporter role to make sure that they're putting the will and preferences of people first, and any abuse of that position is subject to a criminal offence.
Great. Can I ask quickly in that context how you trigger being able to have a supporter if you're not yet using services, for example, but you might be in a particularly vulnerable situation with family? Would you still be seeking to override power of attorney, or could you invoke a supporter? Under what circumstances might you be able to access them?
So we wouldn't be overriding power of attorney arrangements unless there was something in place to suggest that it should be overridden. The way a person appoints a supporter is just if they're entering the aged care system, it's at that point that they would notify that they want someone to be their supporter. That person can then assist them through the assessment and eligibility process that they will go through.
Right. Thank you. How will no worse off principles apply when people are transitioning into support at home?
So there's two aspects to that, Senator. So for people who are either in a package on 12th of September on the National Priority System or assessed as eligible for a package on the 12th of September, they will have the current means-tested care fee arrangements preserved. So that means that if they're not currently paying an income-tested care fee, they won't pay one in the future. And the 14% of people, existing people who pay an income-tested care fee or who should pay an income-tested care fee will pay a reduced amount that will not be above what they would have to pay under the old arrangements. For these people as well, when they move on into residential care, if that's what they do, they will keep the current arrangements in residential care. So that's the current means-tested care fee and the current lifetime cap of $82,000. In addition, when they do move into support at home, they'll have their package level and any unspent funds preserved. So there's another group of people who aren't in the system on 12th of September, and if they're receiving a home care package on 30 June 2025, they'll also have their package level and any unspent funds preserved, but they won't have the benefit of the current fee-paying contribution arrangements preserved.
Thank you.
After this one, Senator, I have to rotate. Thanks.
Yeah, no worries. Thank you, Chair.
You can ask this question, yep, and then I'll rotate afterwards, yeah.
We've had concerns that some organisations who provide services in residential aged care will preference high wealth individuals when the maximum room price is increased and RAD retention is introduced. So can I ask the department, please, what protections there are to ensure lower means residents will continue to be able to access care?
Sure. So there's some existing financial incentives for providers to keep more than 40% of people in their facilities as supported residents. So there's a higher rate of accommodation supplement that gets paid in those circumstances. Overridingly, supported residents are about 45% of the residential aged care market, so we think it's very unlikely that en masse providers will not want to look at what is nearly half of their potential market. So we think that access for supported residents is going to be retained. In addition, though, there'll be a review of accommodation payment arrangements, and we'll look to see whether there's anything that ought to be done to strengthen those provisions.
Thank you, Senator Pratt. Senator Ruston, passing the call back to you. When we get to the last 5 minutes, I've just got a few questions I want to read to give on notice, but I won't wait for answers. But just so you're aware, I'll pull you up just before we close so I can do
great.
that.
Thank
Senator
you.
Ruston.
Thank you very much. Can I just quickly go back to the wait list? Waitlist data? Yes. Yeah, so I know this, it's not necessarily simple, but I'm trying to understand from when an older person would go onto My Aged Care, or somebody would go onto My Aged Care and seek for them to have an assessment, to when they actually receive their package. Do you have an average time that takes?
I have a range of times. I'm not sure how helpful it's going to be.
What's the longest somebody could wait?
So the median...
We'd rather give you what's typical, Senator.
Of course you would.
Yeah. But I should say that, just to caveat this, that in part of what makes this tricky is that both in residential and support home, there's a decision-making process sometimes with the person entering or receiving a service and their family around choosing a provider, and that essentially, these averages will give you the total clock time potentially, but not necessarily be able to break down for you the time that a person might rightly spend in thinking about the service provider they choose or the service they're going into.
Removing...
So it's hard to remove that out of the figure.
Okay.
And we are...
I'm just trying to get an understanding, Mr Lai, around what is a realistic assumption from an older Australian who puts their hand up and says, yes, I need help and I'm going to ask for it. What is a reasonable expectation to say to them how long before they're actually going to receive that care? You can give me a range if you'd like, but clearly I'm not sure that your 15-day answer actually was from when somebody actually put their hand up and said they'd like to be assessed to when they're actually assessed. So I'm just keen to understand there are lots of different pieces that go on this journey, and I just would like to understand what the quantum of all of those pieces on that journey are. Just give me the whole journey.
Senator, I'm just struggling to follow in terms of the connection with the bill for this question.
Well, the main point of this bill is that it seeks to try and reduce the waiting lists for aged care. So unless we can actually understand what the quantum of the situation is, because my next question is actually going to go to the measurement of success of this. So that's why I'm asking about what the timeframes are at the moment, so we can get an understanding of what the benchmark is that we're going to be assessing the success or otherwise of the changes of this bill, because clearly we're trying to make sure that people are getting quicker access to the care that they need. That's the purpose of this bill.
So, to the extent that your answer goes to related provisions to the bill, because this is an inquiry to look into this specific bill and piece of legislation, I'll allow the officials to answer, but just noting that context.
All right. So in relation to the bill will obviously support reform on a number of fronts where we are aiming to streamline delivery of care to older people in Australia. You've talked about the assessment process, and at the moment we are partway through implementing the single assessment system process in an attempt to streamline the wait to receive an assessment. So the data that I mentioned, the 15 days, is the median wait time for an assessment. That was in 23-24.
Yeah, so could you define to me, when you say for an assessment, when does that start and when does that finish?
So referral to an assessment provider.
Referral by whom?
My Aged Care Centre.
Okay, so if I go onto My Aged Care and I say I would like an assessment, the average time I'll wait for that assessment is 15 days.
The median time is 15 days. Mm-hmm. The mean or the average is 19 days.
19 days, okay.
That was across 23-24.
Okay. So I'm just interested also in the fact that you said that there was 78,000 people now on the priority waiting list when there was 69 when I asked you in May. That's a 13% increase in the space of 4 months.
I can clarify the actual number, Senator, at 76,000.
76,000.
As at 30th of September.
Okay. Thanks.
I do note we are sort of straying into territory outside of the bill, Senator Ruston, so if you could keep your questions relevant to the bill.
Well outside of this bill, and that is, I'm just keen to understand the aged care legislation amendment bill that was introduced into the House last week, week before last. I'm just interested to understand the urgency of this bill as it supposedly sits parallel in terms of its provisions to the bill that we're now debating in this inquiry, as to the reasons behind the urgency of that bill being put through the Parliament as opposed to waiting, given the provisions that I can read in the bill relate to the 1st of July 2025.
Yeah, so Senator, the bill does 3 things, and as you pointed out, those 3 things...
Can you just clarify which bill you're speaking about, Ms Connolly, because we're here to inquire on one bill, and so if you're moving to a conversation on another one, can you just state it for the record, please?
It's the Aged Care Legislation Amendment Bill 2024.
Yeah. So it has 3 schedules. It does 3 things. All of those 3 things, as you've mentioned, are also covered by the bill that we're talking about today. The view of government was that it was important to proceed with these 3 particular amendments regardless and in advance of the passage of the new Aged Care Act. They are really important pieces of program management and program administration that we would look to do regardless and as soon as possible. The first relates to supporting our assurance program in relation to residential aged care. It essentially picks up the approach that we've taken in relation to home care and makes sure that we have similar powers and approaches in the residential aged care space sooner rather than later. So it essentially requires providers to provide us with documentation to assure things like care minutes.
So can I just ask you there, the provisions of this bill that we're talking about now, the legislation bill,
yes,
do they come into effect before the 1st of July 2025?
The legislation amendment bill is proposed to commence from 1 January 2025.
Okay, so you're just bringing it forward 6 months instead of waiting?
That's right.
Okay. So what is the urgency? What does that 6 months mean?
It's just sensible program administration, Senator. So there's an element of protecting against any potential delay in the new Aged Care Act. This is something that government would be doing regardless, and it certainly is reflected in the new Aged Care Act, but designed to make sure we have accurate information from providers in the residential aged care space in the same way that we already have in relation to the home care space to support our assurance program. There's another element that relates to income and asset determination information that we receive and in the residential aged care space. That allows us to make sure that we can match...
That's okay. I've been briefed on the bill. I just was trying to understand what the urgency was around it in terms of it's provided in the new bill, why we needed to have another bill with only 6 months efficacy. And some of it's not even the 1st of January. Some of it doesn't happen until the 1st of July. So are there any other pieces of legislation that are likely to be introduced between now and this bill coming into full effect? Is there a transition bill, as an example?
Senator, we spoke about that last time.
So when are we seeing that?
The answer that I gave last time was November.
I'm sorry?
November.
Okay. So you want us to pass this bill before you give us the transition bill? Is that the proposal?
I don't think it's a really appropriately phrased question to the department, Senator.
Sorry. So is it the department's understanding that the bill for transition will not be seen prior to the passage? If this bill is passed in November, will we have seen the transition bill before this bill is asked to be voted on?
It's a difficult question for me to answer, Senator, because I'm not involved in parliamentary scheduling, so I can't say one way or the other.
Okay. Can I just ask you, do you have the number of aged care homes that have closed since the beginning of the year?
Senator, we don't have that. We're able to take that on notice and provide it to you, or we can we would normally provide it in set estimates to you.
Yeah, well, we have estimates in a couple of weeks. So again, just in terms of the questions, we'll keep them.
What would be really good, and maybe this is take it on notice, provided as soon as you possibly can. I'd like to know when we're actually going to see the future tranches, and you said you were in the process of getting a timeline around when OPC can get you that information back. It'd be really good to understand when we will see the transition bill. It'd also be good to understand the timing of the IHACPA determinations in relation to pricing and costing going forward, so that we can at least get some sort of idea about the timeframes within which full information will be available to the sector, so there can be a reasonable understanding of what those transition provisions, first of all, are going to take in terms of time, and secondly, going to take in terms of cost. Because as we're sitting here today, there's a lot of faith being placed in information that we don't have. Can I ask you around the determination in relation to the care management caps? Where did that come from? What was the basis behind the decision to cap care management at 10%?
Senator, so Nick Morgan, supported Home Reform Branch. The decision around the 10% care management was made as part of the program design, following a range of consultation with the sector about the levels of care management that is, provided today.
With the sector, we haven't had one person from the sector say that they are charging 10% for their care management. So, what was the process then after your consultation with the sector to make a determination which is clearly a lot lower than the sector were suggesting was needed to optimise the service that they were providing older Australians?
The level of care, what we were looking at is the hours of care management and the definition of what is included in care management. A number of providers today levy, a care management fee. I think the average is around 17%. That includes, but they use that funding for a range of purposes, including...
no, I understand that. I'm just understanding what your process was to make the determination about.
I'm just answering that question.
Mr. Morgan, yes, Mr. Lai.
We're trying to answer that. I think it's important. The context here is important.
Yeah.
How we got to
we'll
where
remind senators if we can try not to interrupt the witnesses. But Mr. Morgan, if you could come to your answer.
We looked at the hours that are delivered. The 10% care management, arrangement would pay for around somewhere between 1 hour a month for the lowest levels of packages, up to, for the highest budget, around 6 hours a month. On top of that, there's a loading that is provided in addition to that 10% in respect of people who are have been referred by a care finder, homeless or at risk of homelessness, a care leaver, First Nations person, or in receipt of a veteran's supplement. That's equivalent to an extra 1 hour per month of care management. So for that group, I said it's from 1 to 6 at 10%. When you add in the loading for those clients, it's between 2 hours a month, 7 hours per month. And those figures are not inconsistent with the discussions we had with service providers around the level of care management that's required. So that's where we landed on the 10%. A lot of the feedback I'm receiving is that it goes to the use of the care management fees. The feedback I'm getting is that'll make us unprofitable, whereas the feedback hasn't been so much about the level of care management being delivered. So, I'm not sure. The feedback we've received, somewhere in the order of 2 to 4 hours of care management, and that's the order in which, that's the order of magnitude that we're talking about here.
Okay. All right. I'm sorry I've run out of time. I'd have loved to have gone further. The Scrutiny of Bills Committee report, the Joint Committee on Human Rights tabled its report earlier this month and then raised a few issues in relation to this Act. Particularly, it noted that it was difficult to have a fulsome parliamentary scrutiny on the bill, as half missing because of the rules. And it made a comment, which I'm interested in your response to, that restrictive practices, however, ultimately the strength of these safeguards will depend on the rules and how they're applied in practice. And then it went on in terms of supports and advocates and said, that the committee considers the human rights compatibility may be assisted were the bill to be amended to clarify what constitutes exceptional circumstances for the purpose of making a determination that a supporter has a decision-making authority. So we've got a very powerful committee who's concerned about the lack of information as it relies to this. Have you seen that report, and have you got any concerns about some of the things that have been raised in that report, and are you preparing a response to that report?
We've seen both of those reports, Senator, and the Minister is responding to the questions that have been raised.
Okay, thank you.
Just to clarify, in relation to restrictive practices, that's one of those areas of rules where we're looking at substantially the same as the current legislation. So there's not any new aspects in that.
Yeah. So when are we likely to see the response to that? Would that be prior to the legislation being brought on for a vote?
That will depend on when those committees publish the responses.
Yeah, okay, thanks. So just there were some concerns raised in the committee in relation to some of the regulatory powers of the Commissioner, and particularly it was raised with us about the unlimited discretionary power to create a condition of registration without any requirement for justification. So I'm keen to understand where, if there's any other place that you can point to where a Commissioner or a regulator was given an unlimited, unfettered power to do something, because it sort of seems a little odd in terms of the rule of law that we operate in this country, that you would just hand over a power of that magnitude to a Commissioner. So I'm just wondering if you could point to anywhere else in legislation or regulation in this country where an unlimited power without justification was granted to someone.
So, Senator, I believe you're referring to Section 143, which enables the Commissioner to place specific conditions on a registered provider. It's not an unlimited power. It, of course, has to be considered alongside the functions of the Commissioner, which are set out in Chapter 5 of the bill, so it has to be read in that context. It provides very important flexibility for the regulator to manage matters that are specific to a particular provider, and it is modelled on provisions in the NDIS Act, which the NDIS Quality and Safeguards Commission has. It's also a reviewable decision under Section 556 of the bill, noting particularly that the capability review of the Commission recommended that more of the Commissioner's decisions would be reviewable, so it is a reviewable decision.
I raise this mainly because there has been, I suppose, a lack of relationship between the Commission and the sector, and these kinds of clauses, no matter the best intentions that you've just outlined, Ms Metz, don't go very far in terms of rebuilding that trust in the institution. So can I just ask you, a number of providers raised the issue of the discrepancy in relation to payroll tax, because obviously for-profit providers pay payroll tax. There's an exemption for not-for-profit providers. My understanding is that in terms of your pricing, you take into account payroll tax when you make the assessment, but it's actually amortised across the entire sector. Is that correct?
Is
you
this
were looking at me very strangely.
IHAC for costing?
Sorry?
I think you'd have to, if this is a question about IHAC for costing, I think you'd have to ask IHAC per that question.
Or we could take it on notice.
That'd be great. If you could take it on notice. I'm just really interested to understand, because it just really worries me that, well, first of all, it's disproportionate, because, I mean, obviously, if somebody is required to pay payroll tax, then they're obviously at a disadvantage. And I'm just interested in whether you're concerned that a massive amount of federal funding is being provided in support of aged care, which is only right and proper. Then the states and territories are having a big old bite of it. It never used to be the case. There used to be exemptions for payroll tax. Now the exemptions are only in place for not-for-profit. So if you could just give me a bit of background on this, that would be great.
Just confirming you're happy to take those questions
We're
on
happy
notice.
to take it on notice.
Yeah.
I mean, there used to be payment to compensate providers for payroll tax. I think I believe it was abolished in the first Abbott budget.
Yep. So what the decision, though, in terms of the costing as it is at the moment, my understanding, which is you can take this on notice, is that IHACPA does take it into consideration because it was transferred into the pricing, but the pricing is actually amortised, so you get ANAC is the same.
We don't pay two prices for services
that's what I mean.
that do and do not.
No, you don't pay two
tax,
prices.
right.
So I'm just interested to understand that.
So, Senator, you seem clear about the way what's happening. I'm just checking.
Oh no,
what we would
I'm
ask them
actually
to.
not clear. it was just raised, and so I was trying to seek some confirmation because I wasn't sure
So can
how
you
it was
just
done.
clarify the question being placed on notice, Senator Ruston? I think the officials are willing to take
Is
it.
how does IHACPA treat payroll tax in its determination of pricing?
Is that clear, Mr Lowe?
Yeah.
Thank you.
Yep, thanks. And the same thing, you said you'd take on notice the number of closures since the start of the year. Another question, what is the process in relation to the removal of the worker voice within the bill? When is that coming out?
That's a matter for Parliament, Senator.
So you're not drafting amendments or anything to that effect?
Well, I'm not sure we can answer that question, Senator, for you.
Yeah, if you could get me an answer, and you can take that on notice as well. So just interested, earlier on you were talking about education and providing information around to families of older Australians, the sector, what is required. Have you commenced your education campaign or are you waiting until the bill has been passed before you actually start that education campaign?
I think, Senator, Mr Pugh probably outlined a series of things that we're doing with each segment of our stakeholder population, so older people and their families being one group, and that's been a continuing process. And I think, I would just say that what we're committed to doing is, taking the evidence we've heard from the inquiry process and making sure we're amplifying that to that stakeholder group and being more specific, particularly in the run into 1 July, so we can help make sure that people aren't concerned, they don't understand the detail as it's going to apply to them. So there's a range of activities, but I wouldn't describe it as about to commence or starting. We've been doing that for 2-3 years now, but we're at this point we've got to get very practical and very and repeat that advice to each of our stakeholder groups.
So just by way of example, on the new regulatory model, we have had information published on that model for almost a year now. We're currently working with a small number of providers to pilot our registration categories activity, providing information to the sector about how they get in contact with us, and we'll be broadening that out in coming months.
Thanks, Ms Laffin. I just have a few questions I need to place on notice now for you. So 3 questions. First, the committee has heard concerns from providers that the definition of a responsible worker captures workers who are engaged by the provider but who do not deliver aged care services. I just wanted your advice on whether you do believe that is a risk. My second question is, can you explain to the committee how the complaints process will work and how rights will be enforced by the Complaints Commissioner? And we have also heard concerns about the civil penalty amount for an aged care worker's failure to comply with the Code of Conduct, which is the maximum of 250 penalty units or $78,250. Can you provide an explanation to the committee about how these amounts were arrived at? So if you could take those on notice for me. And on that note, I'd like to thank you for your evidence today. We are reporting on the 31st of October. I would be very grateful if we could have returns of these questions on notice by the 24th of October, as we are literally writing our report, and that would be very useful in terms of supporting that report. And there were a number taken, but otherwise that concludes today's hearing, and I want to thank you all for appearing this afternoon. To our Secretariat, Hansard and Broadcasting have had a pretty busy day up here, so thank you for slotting us into your schedule. But with that, the committee now stands adjourned. Thank you.
is